Welcome back, everyone. Ready to dive into another complex legal case with us?
Always up for a challenge, especially when it involves digging into the nuances of a trial that really gripped the nation.
Today, we're looking at the Oklahoma City bombing trial. Yeah, you heard that right, the one involving Timothy McVeigh. This case, as you can imagine, was emotionally charged and legally complex, and the court documents we unearthed from the 10th Circuit Court of Appeals reveal some fascinating insights into how everything played out. Now, we're assuming you have some knowledge of the bombing itself, the devastating events of April 1995.
Right, the Alfred P. Murrah Federal Building reduced to rubble, 168 lives tragically lost. It's a moment seared into our collective memory.
Exactly, so we won't dwell on the details you likely already know. Instead, we're zeroing in on the legal battles fought during McVeigh's trial, and believe me, there were plenty.
It's amazing how much goes on behind the scenes. The legal maneuvering, the arguments over evidence, the jury selection process. It's all crucial to understanding how a trial unfolds and how justice is ultimately served, or at least attempted.
Right, and this trial in particular was just as explosive as the bombing itself, figuratively speaking, of course. So first, let's rewind a bit. Picture the media frenzy after McVeigh's arrest. The public was outraged, demanding justice, and the emotional impact, especially in Oklahoma, was immense.
Absolutely. The court actually decided to move the trial all the way to Denver to ensure a fairer process. They even considered Tulsa for a while, but ultimately decided the entire state was just too close to the tragedy, too emotionally charged.
Wow, they had to move the whole trial out of state. That's how intense things were.
It was unprecedented, but necessary to try and guarantee a fair trial for McVeigh, regardless of the heinous nature of the crime.
Okay, so the stage is set, the trial's in Denver. Now McVeigh's defense team had their work cut out for them. They immediately faced an uphill battle, starting with the issue of pre-trial publicity.
It's a common concern, especially in high-profile cases. Like, how do you find impartial jurors when the media is saturated with information, opinions, and sometimes even misinformation about the defendant?
Right, it's all over the news, everyone's talking about it. How do you ensure a jury hasn't already made up their minds? McVeigh's lawyers were particularly concerned about leaked information regarding a possible confession. They argued this widespread knowledge would taint the jury pool.
This is where we get into the legal concept of presumed prejudice.
Presumed prejudice? Sounds intense.
It is. It's a high legal bar to clear, basically arguing that the publicity surrounding a case is so pervasive and damaging that it's impossible to find an impartial jury.
So are there any famous cases where prejudice was actually presumed?
Oh yeah, there are a few landmark cases that come to mind. Cases like Shepard, Estes, and Rideau. Those involved media circuses that were just out of control, making a fair trial practically impossible.
So those were extreme situations where the media frenzy basically poisoned the well, so to speak.
Exactly. And the courts of those cases had no choice but to acknowledge that finding unbiased jurors was simply not going to happen.
Okay, so how did the appeals court rule in McVeigh's case? Did they buy the presumed prejudice argument?
They didn't. The court concluded that moving the trial to Denver significantly helped mitigate the risk of bias. Plus, they pointed out that the confession report was basically hearsay, rumors swirling around, not a confirmed, admissible piece of evidence.
So changing the venue and the unconfirmed nature of the confession helped McVeigh's chances of a fair trial.
Yes, and the court also highlighted the extensive efforts made to screen potential jurors. They used detailed questionnaires, individual questioning, all designed to weed out those who couldn't be impartial.
So they were really trying to ensure that the jurors could set aside any preconceived notions and judge the case solely on the evidence presented in court.
That's the goal, right? To create a level playing field, legally speaking, even in a case as emotionally charged as this one.
Right. It makes you realize how delicate this process is, finding the right people to decide someone's fate, especially when the stakes are so high. But hold on. Wasn't there an incident with a juror during the McVeigh trial? Something about them potentially knowing the verdict beforehand.
You're thinking about the alternate juror who allegedly made a remark about already knowing the verdict. This incident actually highlights an important distinction in legal terms.
Okay, lay it on us. What distinction are we talking about here?
We're talking about extraneous influence versus intra-jury misconduct.
All right, those sound pretty technical.
Let me break it down. Extraneous influence is when a juror is exposed to outside information that could bias their decision. Think media coverage, conversations with people outside the trial, that kind of thing.
So anything that could taint their view of the case that's not part of the official proceedings.
Exactly. Now, intra-jury misconduct is different. This involves something improper happening within the jury itself.
Okay, so like jurors bullying each other or maybe prejudging the case before hearing all the evidence?
Exactly. And courts generally consider intrajury issues less serious because, while still problematic, they don't involve bringing in totally new, outside information that could unfairly sway the jury.
That makes sense. So how did the judge handle this juror situation? Did they hold a hearing to investigate?
They could have, but a hearing in a high-profile case like this one can be risky. It could create even more media attention, potentially derailing the entire trial.
Yeah, you wouldn't want to make things even more chaotic.
Right. So the judge opted for a different approach. Instead of a full-blown hearing, they addressed the situation with clear, strong instructions to the jury.
A verbal smackdown, basically.
You could say that the judge really emphasized the importance of impartiality, reminding the jury that their decision had to be based solely on the evidence presented in court, nothing else.
It's fascinating how a judge can steer the course of a trial with their words, with those instructions.
It's a delicate balance, for sure. They have to uphold the integrity of the process while also managing the complexities of human behavior, both inside and outside the courtroom.
It makes you wonder how often these kinds of juror issues pop up and how differently they're handled in less high-profile cases.
It's a good question to ponder, for sure. Okay, moving on. Let's talk about McVeigh's attempts to shift the blame, to point the finger at someone else.
This is where it gets interesting. He tried to implicate a group called Elohim City, right? A white supremacist organization.
Exactly. He claimed that an informant, Carol Howe, had crucial testimony about their involvement in the bombing. And he also argued that the FBI suspiciously scaled back their investigation into Elohim City after his arrest.
Trying to create reasonable doubt by suggesting someone else was pulling the strings.
Classic defense tactic, but it's not always easy to pull off. Legally speaking, introducing what's called alternative perpetrator, evidence has specific requirements.
So you can't just throw out random accusations and hope they stick.
You got it. The law demands more than just suspicion. You need a clear, solid link between this other party and the actual crime itself, more than just speculation.
So McVeigh had to show that Elohim City wasn't just a group with extremist views, but that they were directly involved in planning and carrying out the bombing.
Precisely. He had to demonstrate a direct connection, not just cast doubt on the government's case.
And was he successful? Did the judge allow him to present this evidence about Elohim City?
The judge ultimately shut it down. There were concerns about confusing the jury, shifting the focus away from McVeigh's guilt or innocence. It's a delicate balance.
So the judge felt that bringing in Elohim City would muddy the waters, create a distraction from the core issue of McVeigh's actions.
Exactly. Remember, the trial had to stay laser-focused on McVeigh, on his actions and his culpability, not put the FBI's investigative methods on trial.
Right. It makes you think about all the legal chess moves happening behind the scenes, the strategies employed by both the prosecution and the defense to shape the narrative, to control what the jury sees and hears.
It's a high-stakes game, for sure. Now, on a related note, McVeigh also challenged the very language used in the charges against him. He argued that to be found guilty of mass destruction, the government had to specifically prove he intended to kill.
Interesting. So he's arguing that just causing a massive explosion isn't enough. They have to prove he specifically set out to kill people.
That's the gist of it. It gets into the nitty-gritty of legal wording, specifically two key statutes, 18 U.S.C. Section 2332A and 18 U.S.C. Section 844FL.
Okay, I'm not a lawyer, so you might have to break that down for me. What do those statutes actually say?
In simple terms, these laws focus on acts committed knowingly and maliciously. And McVeigh's team argued that this language doesn't automatically equate to premeditated murder. They said it left room for interpretation.
So just because an explosion resulted in death doesn't necessarily mean that death was the intended outcome.
Exactly. They're playing on that nuance, that distinction between causing an explosion and specifically aiming to kill.
It's like, yes, he knowingly created a dangerous situation, but did he specifically set out with the goal of causing those deaths?
That was the crux of their argument. Now, the prosecution, of course, had a different interpretation.
I can imagine.
They argued that the phrase, "if death results" in these laws, is more about determining the severity of the punishment, not a core element of the crime itself.
So it's more about how the act is categorized and punished, not about proving a specific intent to kill in the first place.
Right. It's similar to how other crimes have varying degrees of severity based on the outcome. Even if the initial intent wasn't necessarily to cause the worst possible result, The outcome still matters when it comes to punishment.
Right, like a bar fight that accidentally leads to someone's death. The intent might not have been murder, but the outcome is still a tragedy with serious legal consequences.
Exactly. It's a complex area of law, but McVeigh's challenge highlights how carefully wording is scrutinized, how every phrase can be debated and interpreted differently.
It makes you realize how much power words have in the legal realm, how a single word or phrase can make all the difference. Now, before I move on, we need to address something that's undoubtedly difficult here, but it's crucial to understanding this trial. We need to talk about victim impact testimony during the guilt phase.
This is where things get especially emotional. We're talking about firsthand accounts from those directly affected by the bombing, their pain, their loss, their trauma.
And it's important to note that we're not just talking about statistics or dry facts. We're talking about real people sharing their experiences, their heartbreak, the impact this event had on their lives. I remember seeing footage of Michael Norfleet, a survivor who described his harrowing escape from the building with a fractured skull.
His testimony was incredibly powerful. You could feel the raw emotion, the fear, the confusion, as he recounted those moments of chaos and survival.
And then there was Susan Hunt. She talked about helping a survivor who didn't even realize they'd lost an eye in the blast.
It's a stark reminder of the physical and emotional trauma inflicted, the lasting scars this event left on so many.
And then there's Helena Garrett's story. Just heartbreaking.
Helena was frantically searching for her son amidst the carnage, pleading with rescuers to be gentle with the children's bodies. She didn't yet know the extent of the tragedy, the unimaginable loss she was about to face.
Those stories are incredibly difficult to hear, but they're important, right? They remind us that this wasn't just an abstract event. It was a human tragedy with real people at its center.
Absolutely. And from a legal standpoint, victim impact testimony serves a specific purpose. It demonstrates the real-world consequences of the crime, the human cost, beyond just statistics.
So it helps the jury grasp the gravity of the situation, the ripple effects of the crime, the pain inflicted on individuals and families.
Precisely. It helps them understand the full scope of the tragedy, not just the legal technicalities.
But surely McVeigh's defense team objected to this, right? It seems like it could be pretty prejudicial, swaying the jury with emotion.
He did. They argued that it was too emotionally charged, that it could unfairly bias the jury against McVeigh.
But the judge allowed it.
He did, with some caveats. He recognized the potential for prejudice, but also acknowledged the importance of presenting a complete picture of the crime's impact.
So a delicate balance, as always.
Exactly. The judge gave the jury careful instructions, reminding them that their decision had to be based on facts and law, not solely on emotion.
So acknowledging the emotional impact while ensuring a fair, unbiased verdict.
It's a tightrope walk, that's for sure. Now, interestingly, the appeals court later ruled that even if some of the testimony was borderline inadmissible, it wouldn't have changed the outcome given the overwhelming evidence against McVeigh.
So even if some of the testimony was deemed a bit too emotional, it wouldn't have altered the final verdict.
Right, which highlights the legal complexities involved, how courts weigh the probative value of evidence against its potential prejudicial effect.
It's all about finding that sweet spot, balancing those competing interests. But it's never easy, especially in a case like this. We've covered so much ground already. The change of venue, the pretrial publicity, the attempts to blame Elohim City, the debate over McVeigh's intent, and now the emotional weight of victim impact testimony.
And we're just getting started.
There's so much more to unpack: McVeigh's challenges to the jury instructions, the restrictions he faced during jury selection for the penalty phase, his attempts to introduce even more controversial evidence. It's a legal roller coaster ride.
Yeah, buckle up, because we're about to dive into the penalty phase, where the stakes get even higher and the legal battle's even more intense.
Okay, so the jury found McVeigh guilty, but the legal battle wasn't over, not by a long shot. We're now entering the penalty phase, where the jury has to decide whether to impose the death penalty. Talk about pressure.
Right, the stakes are incredibly high. It's not just about guilt or innocence anymore, it's about life or death. And both sides bring their A game, arguing passionately for their desired outcome.
I bet. And jury selection for this phase got pretty heated too, right? I remember reading that McVeigh wanted to really dig into potential jurors' views on capital punishment, but he faced some pushback.
You're right. This is where we bump into a landmark Supreme Court case,
Yep.
Morgan v. Illinois. This case basically established a defendant's right to question potential jurors about their willingness to actually impose the death penalty, especially if they hold strong beliefs about it.
Okay, that makes sense. You want to make sure the jury isn't stacked with people who are automatically pro-death penalty, especially in a case like this.
Exactly. It's about ensuring a fair and impartial jury. People who can genuinely weigh the factors and make a reasoned decision based on the law, not just their personal beliefs.
So, what kind of questions was McVeigh's team trying to ask? Were they getting into specifics about hypothetical scenarios and how a juror might vote?
They wanted to, yeah. They were interested in both what we call general Morgan questions, which probe a juror's overall stance on capital punishment, and specific Morgan questions, which get into those hypothetical situations and how they might influence a juror's decision-making.
So, really trying to understand how a juror might actually apply the death penalty in different situations, not just their theoretical stance on it.
Exactly. But the court, as you mentioned, put the brakes on some of those more specific questions.
So, they were okay with general inquiries about capital punishment, but drew the line at delving into detailed hypotheticals.
Right? They felt those specific scenarios could bias jurors or lead them down a particular path, even unintentionally. It's a tricky balance, allowing the defense to explore potential biases while also keeping the focus on the evidence and the law at hand.
I see. So they wanted to avoid planting seeds, so to speak, and make sure the jury was making decisions based on the specific facts of the case, not abstract hypotheticals.
Precisely. And they also felt that the existing selection process, with the questionnaires and the general questioning, had already addressed concerns about impartiality.
Makes sense. So McVeigh is facing the possibility of the death penalty, and he's limited in how he can question the very people deciding his fate. What was his next move? Did he try to bring up Elohim City again, that group he'd tried to pin the bombing on earlier?
He tried to bring them back into the picture during the penalty phase. This time, he argued that their potential involvement meant he played a lesser role in the bombing, making him less deserving of the death penalty.
Interesting strategy. So he's not trying to claim innocence anymore. He's trying to lessen his culpability, to paint himself as less of a mastermind.
Exactly. And to understand this tactic, we need to delve into the concept of mitigating factors.
Mitigating factors, fill me in. What are those?
Think of them as reasons why a jury might be less likely to impose the death penalty, even if the defendant is guilty. They're like counterweights to the aggravating factors that point towards a harsher punishment.
So things like the defendant's age, mental state, lack of prior criminal history, anything that might make the jury more sympathetic, less likely to see them as deserving of death.
You got it. And McVeigh's team was trying to argue that even if he was involved in the bombing, maybe he wasn't the driving force, that Elohim City had a bigger role than initially thought.
But wouldn't that contradict his earlier attempts to blame them entirely? Now he's admitting some level of involvement.
Right, he can't really claim complete innocence at this point. But he's trying to use whatever legal tools are available to avoid the death penalty. And to do that, we need to look at the Federal Death Penalty Act.
Okay, the Federal Death Penalty Act. What's that all about?
It basically lays out specific mitigating factors a jury can consider. One factor is minor participation, meaning the defendant was involved but not the key player, not the one who planned or directed the crime.
But wouldn't that ship have sailed for McVeigh, so to speak? He'd already been convicted as the mastermind?
Right, he couldn't directly claim minor participation anymore.
Mm.
But there's another option, a catch-all mitigating factor, that allows the defense to present any other relevant information about the defendant's character or the circumstances of the crime, hoping to sway the jury toward mercy.
So a kind of last-ditch effort to humanize the defendant, to make them seem less deserving of the ultimate punishment, even if they're guilty.
Exactly. It's a fascinating aspect of the law, this recognition that even in the face of horrific crimes, there might be reasons to show leniency.
Right, it acknowledges the complexities of human behavior, the idea that there's always more to the story. So, did the judge allow McVeigh to bring up Elohim City again during this penalty phase? Did he get to call that informant, Carol Howe, to the stand?
He tried. You really wanted her testimony to be part of his defense. But the judge ultimately ruled that it wasn't relevant enough to McVeigh's character or the specific circumstances of the crime.
So even though Elohim City might have played a role, the judge felt that their involvement didn't directly say anything about McVeigh himself, about his motivations, or the reasons why he might deserve a less severe punishment.
Right, the focus had to stay on McVeigh, on who he is and why the jury should potentially spare his life. It's not about relitigating the entire case or exploring every possible conspiracy theory.
Makes sense. It all comes down to legal relevance, to whether a specific piece of evidence actually helps the jury understand McVeigh and make an informed decision about his sentence.
Exactly. It's a delicate dance, trying to present a compelling defense without getting sidetracked or introducing irrelevant information that could confuse the jury.
So Elohim City was a no-go. But what about that other event that loomed large in McVeigh's mind, the Waco siege? I know that had a huge impact on his anti-government views.
You're talking about the 51-day standoff back in 1993 between federal agents and the Branch Davidians, right? The one that ended tragically with a fire that killed dozens of people, including children.
Exactly. That event really fueled a lot of anti-government sentiment, and it's clear that McVeigh saw it as a turning point, a justification for his actions.
It definitely played a significant role in shaping his worldview. And legally speaking, the court did allow him to present evidence about his beliefs and knowledge of Waco at the time of the bombing.
So they acknowledged that his interpretation of Waco, even if flawed, could have contributed to his actions, and they considered that a mitigating factor.
Right. They recognized the importance of understanding McVeigh's mindset, the context of his actions, even if his interpretation of events was skewed. But they drew a hard line in evidence about the objective truth of what happened at Waco.
So they were okay with McVeigh's subjective view of Waco, his personal interpretation, but not with delving into whether the government was right or wrong in their handling of the siege.
Exactly. They didn't want the trial to become a referendum on Waco. They wanted to keep the focus on McVeigh, on his motivations, and on whether those motivations, however misguided, warranted some level of mercy.
I see. So jury could hear about McVeigh's beliefs about Waco, but they couldn't hear evidence challenging the official narrative or relitigating the government's actions. It's a subtle but important distinction.
Exactly. And it goes back to the idea of relevance. Does this particular piece of evidence actually help the jury understand McVeigh and his actions in a way that's relevant to the sentencing decision?
Right. It's not about determining who is right or wrong at Waco. It's about understanding McVeigh and the factors that led him down this path.
Precisely. Now, this distinction also has roots in a legal precedent, specifically Skipper v. South Carolina. That case basically said that mitigating evidence has to offer genuine insight into the defendant's character or the circumstances of the crime.
So the objective truth of Waco, while important in its own right, wasn't directly relevant to McVeigh's character or the reasons why he might deserve a less severe sentence.
That's the court's reasoning. It's fascinating how these legal precedents shape the boundaries of a trial, what's admissible, what's relevant, and what ultimately gets presented to the jury.
Okay, we've covered jury selection, the attempts to bring Elohim City back into the mix, and the legal wrangling over Waco. What about victim impact statements during this penalty phase? I imagine those were even more intense given what was at stake.
You're absolutely right. The prosecution brought in 38 witnesses to testify about the impact of the bombing. Family members, survivors, rescue workers. It was a powerful display of the human cost of McVeigh's actions, the ripple effects of that single act of violence.
38 witnesses, that's a lot of people sharing their stories, their pain. I can only imagine how emotionally charged that must have been.
It was incredibly moving and heartbreaking. Some shared their last contacts with loved ones, the everyday moments that now carried so much weight.
Like what? Give us an example, if you can, of the kind of testimony they shared.
Jenny Witcher talked about her husband's final goodbye, how her children regretted not hugging him tighter that morning. It's those small gestures of love and connection, now lost forever, that really hit you hard.
It's a stark reminder that behind the statistics, behind the headlines, are real people whose lives were shattered, whose families were torn apart. It's easy to forget that when you're dealing with an event of this magnitude.
Exactly. And Kathleen Triner described her daughter's final, real hard kiss on the lips and hug before dropping her off at the daycare center. It's those everyday moments, now imbued with such tragic significance, that really stay with you.
The ordinary becoming extraordinary in the worst way possible. And it wasn't just about the loss, right? There was also testimony about the agonizing search for missing loved ones, the uncertainty and fear in those early hours and days.
Absolutely. Helena Garrett, who we mentioned earlier, had to identify her son's body based on a tiny detail, a little hard on his foot. It's those small, specific details that make the tragedy so visceral, so real.
It's impossible to hear those stories and not be moved, not to feel the weight of their loss. And then there was Bud Welch, whose daughter was killed in the bombing. He actually spoke about forgiving McVeigh, choosing a path of peace instead of revenge.
His testimony was incredibly powerful, a testament to the human capacity for forgiveness, even in the face of unimaginable pain. He refused to let hatred consume him, and his words resonated deeply with many.
It speaks to the complex emotions surrounding this case, the anger, the grief, but also the resilience, the hope that some found in forgiveness. It's a reminder that even amidst tragedy, there can be moments of grace and humanity.
Beautifully put. Now, it's important to note that this wasn't the first time victim impact statements were allowed in a death penalty case. The Supreme Court had already ruled on their admissibility in Payne v. Tennessee.
So there was already legal precedent for allowing these voices to be heard, even though it's clearly emotionally charged and could potentially influence the jury.
Exactly. The Payne ruling basically said that jurors should hear about the human cost of a crime, the personal stories of loss and suffering, to help them weigh the appropriate punishment.
So it's not just about the legal arguments, it's about understanding the real-world impact of the crime, the pain inflicted on individuals and families.
Right. It gives a voice to those who might otherwise be silenced, whose stories might be lost in the legal back and forth.
But of course, McVeigh's defense team objected to this. They argued that it was too much, too emotional, that it could unfairly bias the jury.
They did. They used the phrase empty chair to describe their concern.
Empty chair. What did they mean by that?
They argued that the emotional impact of so many victim impact statements created a sense that the victims themselves were present in the courtroom, even though they couldn't speak for themselves.
So it's like their absence is a presence, a silent plea for justice, for retribution?
Exactly.
Yeah.
And McVeigh's team argued that this could unfairly sway the jury towards the death penalty, driven by a sense of sympathy for the victims and a desire to avenge their loss.
It's a powerful argument. It raises questions about how much emotion is appropriate in a legal setting, how to balance the need for justice with the potential for bias.
It's a complex issue, no doubt, and the judge in this case was acutely aware of those concerns. He urged the prosecution to focus on the objective impact of the bombing, not just raw emotion.
So trying to find a balance between acknowledging the victim's suffering while keeping the proceedings grounded in facts and legal principles.
Right. He also gave the jury careful instructions to weigh all factors, both mitigating and aggravating, before reaching a verdict, reminding them that their decision had to be based on reason and law, not just emotion.
Once again, it's that delicate balancing act, acknowledging the human cost of the crime while ensuring that the legal process remains fair and impartial.
It's a tightrope walk, for sure. And this case, with its high stakes and intense emotions, really put those complexities on full display.
We've covered so much ground already. The jury selection process, the attempts to shift blame, the debate over mitigating factors, and the powerful victim impact statements. It's been a roller coaster ride through the legal and emotional landscape of this landmark case.
And we're not done yet. We still need to explore what the appeals court had to say about all of this, their assessment of whether McVeigh received a fair trial, whether his rights were violated, and ultimately whether his sentence was just.
Okay, we've been through the ringer with this case, haven't we? The bombing, the trial, the arguments, the emotional testimonies. It all culminates here with the appeals process.
The final stage, where a higher court reviews everything that happened at the trial level, ensuring that justice was served, that the law was followed, that McVeigh's rights weren't violated.
Right, because even though a jury reached a verdict, there's always that possibility of an appeal, of a higher court stepping in and saying, hold on, something's not right here.
It's a crucial part of our legal system. It acts as a safeguard, ensuring that even in high-profile cases, even when emotions run high, the process remains fair and impartial.
So what did the appeals court have to say about McVeigh's case? After all that legal wrangling, all those objections and arguments, did they find any reason to overturn his conviction or sentence?
They really had their work cut out for them, going through every detail, every piece of evidence, every legal argument. With a fine-tooth comb, they were looking for any sign of error, any violation of McVeigh's rights, anything that might cast doubt on the trial's fairness.
It's a huge responsibility. They're not just reviewing a case, they're potentially deciding someone's fate.
You're right. And in McVeigh's case, the appeals court ultimately upheld both his conviction and his death sentence.
So despite all the defense team's efforts, all their objections and challenges, the appeals court basically said, nope, the trial was fair, the verdict stands.
Exactly. They acknowledged the horrific nature of the bombing, the intense emotions surrounding it, but they also made it clear that justice had to be served within the confines of the law.
So even though McVeigh's lawyers raised valid points, even though there were moments of intense debate and legal maneuvering, the appeals court concluded that overall the trial was conducted fairly and McVeigh received a just verdict.
Right. And I think this underscores a really important point, that our legal system, even when dealing with incredibly emotional and sensitive cases, is designed to operate with a certain level of detachment.
Detachment, what do you mean?
I mean that the focus has to be on the facts, on the legal arguments, on the established procedures. It can't be solely driven by emotion or a desire for retribution, however understandable those feelings might be.
So it's about removing or at least minimizing the emotional element and focusing on the legal principles at play.
Exactly. The law is, in a sense, a framework for navigating these difficult situations, for ensuring that justice, however we define it, is pursued in a fair and impartial way.
It's like the law is a set of rules, a roadmap for how we deal with even the most challenging situations. It's not always perfect, and it doesn't always satisfy our emotional needs, but it's the system we have for ensuring a certain level of order and fairness.
Well said. In this case, McVeigh's trial really brought those complexities to the forefront, didn't it?
Absolutely. It forced us to confront so many difficult questions, not just about the legal specifics, but about our values as a society, how we respond to violence, how we balance security with individual freedoms.
Right. The Oklahoma City bombing was a turning point in many ways. It exposed vulnerabilities, it fueled debates about extremism and anti-government sentiment, and it left us grappling with the lasting impact of trauma and loss.
It also sparked discussions about the role of the media, the power of images and information, and how those things shape public perception and influence the legal process.
And let's not forget the ongoing conversation about victim impact statements, which played such a crucial role in McVeigh's trial.
Right, those emotional testimonies, those stories of loss and survival, they really highlighted the human cost of the crime.
And they raised important ethical questions about how much weight such testimony should carry, how to balance the need to acknowledge victims' pain with the need to ensure a fair and impartial trial.
It's a delicate balance, that's for sure. And it's a conversation that continues to this day as we grapple with the role of emotion in our legal system. This deep dive has been incredible. We've gone from the bombing itself to the intricate details of the trial, the legal arguments, the emotional testimonies, the appeals process. It's been a journey through a pivotal moment in our nation's history.
A moment that continues to shape our understanding of justice, security, and the very fabric of our society. And as we wrap up this exploration, we hope you, the listener, walk away with more than just facts and figures.
Right. We want you to think critically, to question assumptions, to engage in respectful dialogue about the issues this case raised. Because these conversations are important. They matter. They shape our understanding of the world and our place in it.
So keep learning, keep questioning, keep seeking knowledge, and most importantly, keep engaging with these complex issues. Because that's how we grow, that's how we learn, and that's how we create a more informed and just society.
Thank you for joining us on this deep dive into the Oklahoma City bombing trial. We'll see you next time for another exploration of the legal landscape, the cases that shape our world, and the stories that matter.